Just look at the patterns. This person has experience with seeing these patterns. Next case we cite, another Massachusetts case, Pasteur. What's the issue there? Not a dog bite case, I've already given you two, but a firearm examiner in that case. The court said, and I'm going to quote, a judge may also look to his, let's get it correct, her, for this case, own common sense, as well as the depth and quality of the proffered expert's education, training, experience, read on, to determine reliability. All right? So even in situations where courts have repeatedly said, including dog bite cases, if a doctor has repeatedly looked at, treated, etc., they get to testify with regard to whether they believe a wound is caused by whatever, and in the two cases I've given you, dogs. So the law is very clear for what the position is of the defense with regard to methodology, and that's what this hearing's about. That's why we're here. Is her methodology reliable? And there is one methodology. There's a pattern methodology. She testified to it. And the Commonwealth has no competent evidence whatsoever to counter that. It's remarkable to me that we're being faced with the challenge to whether the defense could put up a defense and put up a witness when there's no opposition to her methodology from, as your doctor has, or your honor has required, a medical doctor that is required under law in Massachusetts. I also, Your Honor, want to go to now what the Commonwealth has argued in its papers, which I think further underscores the waywardness of their argument. On page 11 of their papers, the Commonwealth further attempts to criticize, or excuse me, what we said in our papers on page 11, the Commonwealth further attempts to criticize Dr. Russell for being a, quote, trained emergency room physician as opposed to a professional in the field of canine bites or claw marks, veterinary medical science, forensic odontology, or canine behavior. How does that square with your honor's standard that it must be a medical doctor that speaks to the causation of this injury? By definition, a veterinary medical science person is not a medical doctor. A forensic odontologist, most always a dentist, is not a medical doctor. And certainly canine behavior. And why are those words there? Because that describes exactly the expert that the Commonwealth has sat on since the trial, Dr. Cosby. That's him. And in the book that Mr. Brennan attempted to use, Dr. Cosby has written some of those articles, interestingly enough, citing the very articles that Dr. Russell relies upon for the very pattern methodology. So again, the waywardness of the Commonwealth's argument is they're not addressing the need to have a medical doctor. We are not here arguing over whether the dog behaved correctly. We are here to determine, and this is the focus, what is the medical cause of the injuries to the decedent's right arm? And what we have done, perhaps too thoroughly, is we have established the credentials of Dr. Russell, not only with regard to dog bites, but with regard to medical causation, a broader umbrella. And under that umbrella of medical causation is expertise in dog bite wounds, expertise in motor vehicle accidents, but importantly, expertise in wounds caused by motor vehicle accidents. We never presented her as an accident reconstruction because if you need to be a medical doctor to be able to opine on these wounds, I've established through Dr. Russell, and it's unrefuted by the Commonwealth, that Dr. Russell has never heard of someone who's an ER doctor who is an accident reconstructionist. They're two different disciplines. And lastly, on this point, before I move to my next, if an accident reconstructionist is going to come in and try to testify about the nature of wounds, I think I can predict what Your Honor might do. So In terms of why we are here, it's straightforward. Her credentials are enormous. Her experience is enormous. She has been truthful and honest. Your Honor has the notebook for the exhibits for today and can look and see that she did not make inconsistent statements. By way of example, when she said, when it was alleged that she said possibly was in the question, not in her answer. When it was alleged that she didn't answer your question to a medical degree of certainty, we proved that that was wrong with specific language. So on the methodology, this is straightforward. In the law, in the cases I've given you, in Massachusetts as well as dog bite cases, it is completely accepted for a medical doctor to use their many years of experience in treating these types of wounds, and that's exactly what Dr. Russell did in this case. Now a very important, in my judgment, Your Honor, legal point. The Commonwealth has waived its entire motion, and here's how they did it. I asked Dr. Russell what I refer to in these Daubert hearings as the magic question. I said, do you have an opinion on the cause of the injuries to Mr. O'Keefe's right arm? Yes, I do. What is that opinion? I believe that those wounds were caused by a dog attack. Do you hold that opinion to a reasonable degree of medical certainty? I do. The Commonwealth never objected to that question. To me, that's a waiver of the entire issue. If they thought she was unqualified to answer that question, they should have done what Mr. Lally did in the June 21st trial. Because another part I've got in the notebook for Your Honor to see is she never got the opportunity at the June 21 trial to answer the question of whether she had that opinion to a reasonable degree of medical certainty, because Mr. Lally objected, as is his right, and Your Honor sustained it, and sustained it, and sustained it. That's yet another reason why it's not inconsistent, because at the June 21 trial, she never got to answer that question because of the Commonwealth. But back to the waiver. The Commonwealth should have, at that moment in the hearing, objected, but they didn't, and they have waived that objection for this motion. Lastly, I want to just cover a couple more items that Mr. Brennan had quickly. He kept saying, can't be, equally basis, evidence wholly contradicted. Where's the medical profession to support that? Those are Mr. Brennan's opinions. And respectfully, Your Honor, I don't believe that's even for the court in this hearing to decide. That's for the jury to decide. As almost all of these cases go to, the Labello case that I cited, those arguments go to the weight of the testimony. They go to cross-examination. As Your Honor well knows, you're the gatekeeper to see whether Dr. Russell gets to go to the jury, whether you're going to keep that gate open that I believe you very carefully and judiciously decided on June 18th. And I respectfully submit that gate should be much wider open now, given what Your Honor has heard and the basis for it. But even if Your Honor might be inclined to be interested with, maybe even persuaded by some of the things Mr. Brennan said, those have nothing to do to whether there's a methodology or whether it's reliable. Those are easily answered by DeMunick and Pollack. And that's the end of the inquiry. Everything else is beside the point. With regard to the DNA that the Commonwealth has tried to make so much about, there was only one reason why that was brought up. It was brought up because Dr. Russell answered she didn't need to know much about the DNA. Why? Because the pattern of the wounds are so highly characteristic of a dog bite and a dog attack, and because the authors used the word pathognomonic. But because she was careful, she went through a differential diagnosis. but she was consistently honest and forthright. When she didn't know something, she said so. So in terms of this particular matter, and I'll conclude my points at this point and keep to below the 20-minute mark.
30 minutes.
I'm sorry, 30-minute mark. The tremendous importance of a defendant's right, especially in charges of this seriousness, to present a defense, to present a counter argument to the whole theory of the prosecutor's case. Their theory is that a motor vehicle hit the decedent and caused these injuries to the right forearm. The presumption should be the defendant gets the right to present evidence. Now, they don't have an absolute right. You got to satisfy Daubert, but I believe the satisfaction on the crucial inquiry of qualifications and then the methodology and reliability is overwhelming. So, Your Honor, I would urge that Your Honor find that Dr. Russell is qualified. She's qualified as a medical causation witness, which has her able to not only testify at trial with regard to whether those wounds are caused by a dog attack, but also she can testify, and she's qualified to do so, that it's not from a motor vehicle accident, and she's also allowed to testify with regard to her forensic pathology hat, because contrary to the impression of the first in June, she's been doing forensic pathology as recently as her time at Corcoran. And my last point, Your Honor, is this, and it blends in with the point I made earlier about the jury. Shouldn't a jury be able to hear the alternative theory of the defense? Shouldn't the jury have that information so that justice can be served, so that the best decision can be made about whose theory about these injuries is right? We've satisfied, beyond my view, respectfully, any reasonable doubt about her qualifications and methodology. Let's let everything else go to the jury and decide, so Ms. Reed can have her fair day in court.
Okay. Thank you. We have some scheduling things that we should take care of. There's another motion from the Commonwealth on another Daubert hearing regarding the digital evidence expert.
There is, and also I don't know if it's docketed, but I filed a notice to the court regarding my concerns about ARCA witnesses, and the reason I filed that prior to filing an actual motion is because I appreciate the trial court date. I do not want the defense to be unaware of my intention.
Okay. All right. So let's set a date for a Daubert hearing. Any idea how long you expect it will take regarding the digital evidence expert?
Well, Your Honor, when you say a Daubert hearing, you don't mean an evidentiary hearing. You mean a hearing on whether or not an evidentiary hearing is required.
So we can do that tomorrow, or we can
Well, I can't
set
do
it,
it tomorrow.
or, well, then we'll stay now and do that. Are you ready to do that, Mr.
No,
Jackson?
we just
Then-
got this on. We just got this on January 31st.
Okay.
We've not had an opportunity to respond to it.
December 31st, probably.
What did I say?
January.
Yes. On New Year's Eve. We've not had an opportunity to respond to it. We
Okay.
expect to have an opportunity to respond to it.
How long will it take you to respond to it?
Probably a couple of weeks.
All right, so what I want to do, because I want to set some dates, and if we're not going to have a hearing, we'll cancel it. It's easier than getting the motion, deciding that there'll be a hearing, and setting a date, because we're sticking with that April 1st trial date.
I understand that, but the problem with setting a date for a hearing and an evidentiary hearing requires us to bring someone in from out of state.
No, so what I'm saying is, file your paperwork,
Okay,
all right? We'll set a date for a hearing.
okay.
We'll set an evidentiary hearing date. I just want to lock those in. I'm trying to do them
Okay,
on Mondays or
that's fine.
Fridays for you,
Understood.
thinking that it would be better for your schedule if we tried to accommodate that. but we've got a full session, so,
Mr. Brennan and I talked briefly, I don't want to speak for him, but we talked briefly about the January 27th date. I think all council have that date cleared because it was a trial date at one point in
Right.
our history. So what about the 27th for the motion on Mr. Brennan's Daubert request?
on
Then-
all witnesses, not just, you said you're filing,
The only one he's got is for Rick Green.
what did you file a notice of, you said today?
Notice that I expect that I will likely move to exclude the ARPA witnesses for failure to comply with Rule 14. It's not a Daubert hearing,
Okay,
it's compliance with Rule 14.
okay, so that's different.
Yes. I am waiting for a response from the United States Attorney's Office that I'm supposed to expect next week.
Okay,
If that changes my position, I'll notify the defense in the court. If it doesn't, then I'm going to pursue that motion.
okay.
Aaron, may we be seen briefly at 7 about scheduling?
clear, the 31st will be oral argument at 9 a.m. And if there's an evidentiary hearing, it will be conducted on February 6th. We'll block off the day. And February 7th, and we'll also hear the ARCA motion if there's something on that. So we'll go for the 6th, but we'll leave time if it carries over, so we don't have what happened with Dr. Russell, such a big gap in between. Okay? All right, we'll see everybody then. Thank you.
Thank you. Report, all right, please.
Thank you, everybody.